in debates, particularly those concerning migration and development, the sort of human beings or the sort of human-centered approach is not necessarily evident, right? There's more focus on the economic benefits of migration to countries of origin and destination and so on. So it's important not to lose sight of this important aspect. We also, when we talk about rights-based approach to migration, understand or should understand that issues around migration or labor migration in particular should not be immune from the application of the rule of law. Just because people come from other countries, just because they have to enter to be admitted, doesn't mean that rule of law principles are not applicable in this context, right? Also, we talk about the need for minimum standards, the basic minimum that are important in guiding the formulation of legislation and policy on migration at the national and regional levels. It's important also, and this is particularly relevant to the ILO as well as to the UN system, is that when we have a rights-based approach, we can also ensure that whatever is happening at the national level can be subject to independent and transparent monitoring to ensure also that there is compliance with these minimum standards. And particularly when it comes to ILO standards, they have this unique feature that they have been discussed and agreed, not just by governments, but also by other key actors in the world of work. And here we talk about the representatives, of course, of the workers and the employers, right? Which are, of course, key stakeholders in the world of work. So by no means it's not an exhaustive sort of overview of what is a rights-based approach, but they're just some elements that you can reflect upon. And now, why do migrant workers need specific attention when it comes to the application of these legal frameworks? Well, first of all, again, they are not nationals of the country in which they work. And often they rarely benefit from full equality of treatment with nationals, right? And equality or realizing equality is particularly difficult when labor markets are segmented. So I work, for example, in the Arab States region, where, in some parts of the region, like in the Gulf states, we have segmented labor markets, right? Most workers in the private sector are migrant workers, and in some specific sectors of employment, they are exclusively migrant workers, like the domestic work sector. In construction, they are by great majority migrant workers. So in those contexts, it is very challenging to realize this principle of equality treatment of nationals, okay? Migrant workers also often work in low-wage, precarious employment. And I've listed on this slide the kind of sectors in which they tend to be found, and I've already alluded to this a moment ago. Clearly, this category of migrant workers, the low-wage workers, lower-skilled workers, are at greater risk of abusive recruitment practices. They tend to be the migrant workers that often are subject to paying fees or related costs for jobs. These costs, of course, should be covered by employers, but in many instances, they pay, and this is contrary to labor standards, but they pay to get a job. And sometimes it can be thousands of dollars, depending on the specific labor migration corridor. They're also subject to multiple intersectional forms of discrimination, and this is particularly the case when we talk about women migrant workers, and they're not just subject to discrimination on the basis of the sex, but also on the basis of, for example, race, ethnicity, or nationality, as well as status, social status. And generally speaking, they are more at risk if they are in an irregular situation, right? If they have moved to a country unlawfully without authorization. However, the fact that they may be regular doesn't necessarily mean that they are not at risk of exploitation and abusive treatment. As I've already mentioned, this is often the case when we talk about lower wage or low skilled workers. Okay, so there's just some arguments or reasons why migrant workers do need specific attention, and why international legal frameworks have indeed recognized this group or category of workers as needing this specific attention. So when we talk about the international legal framework, there are various sort of pillars, if you like, or areas of international law. And the two that are relevant, right, to migration, international migration in particular. And the two that I will focus on by and large are labor law, international labor standards, and I'll say something about some key international human rights instruments as well, which also cover labor rights, right? But there are other areas that are obviously relevant. International criminal law, this is where you find the protocols against trafficking in persons and smuggling. We have the law of the sea, obviously relevant to those movements across like the Mediterranean or from East Africa to the Arabian Peninsula. Humanitarian law, the Geneva Conventions, refugee law, and so on, right? So, but my focus will be on labor law and human rights law. So when we talk about international labor standards, now what is really key and very important is that all labor standards apply to migrant workers, right? Unless it's specifically stated otherwise. And this also is not just migrant workers in lawful situations, but also those in irregular situations, right? And of particular importance are the now 10 ILO Fundamental Rights Conventions, addressing trade union rights, forced labor, child labor, non-discrimination in employment, as well as the right to a safe and healthy working environment, right? So all these standards, which are, and certainly the first 8 in this list are widely ratified, are applicable to all workers, including migrant workers. And that is very important because when we look at the more specific instruments of migrant workers, we'll find that they haven't been widely accepted, right? But we know that many migrant workers, and this is also proven in ILO research, are at greater risk, for example, forced labor practices, right? And the conventions addressing forced labor are very widely ratified, including, for example, in the Arab states. Many of the Arab states, or including the Gulf countries, have ratified a number of these fundamental conventions, although they've not, as you will see later, ratified the specific instruments of migrant workers. There are also obviously other applicable standards, the governance conventions dealing, for example, with labor inspection, as well as some conventions of general application, which may not expressly refer to migrant workers in the text, but are obviously very relevant for migrant workers. Take the Protection of Wages Convention, right? This is the convention that tells you that all workers should be paid on in a regular way, and various principles relating to the payment of wages, right? And we know, and particularly again related concerning during the COVID pandemic, many migrant workers were not paid their wages, lost their jobs. In the Arab region and the Gulf states, we also find that issues around non-payment or late payment of wages, or what are often referred to as so-called end of service benefits, that there are deficits in this regard. So an instrument like this is of particular relevance to migrant workers because it applies to all workers, of course, although it may not expressly refer to migrant workers. On the other hand, there are also numerous instruments, and I've just provided a selection here of both binding conventions and non-binding recommendations, okay, where there are express provisions on migrant workers. And I've highlighted here in red some key instruments, which I think are important, but this is just a personal selection. But as you see, then clearly the Domestic Workers Convention, right? Because we know that a large number, and particularly in the region I'm in, nearly all domestic workers are migrant workers. Many are women, but there are also many men domestic workers in this region. And clearly, it's important for that to be recognized in the Domestic Workers Convention. You have a recommendation on workers' housing, where particular attention needs to be given to migrant workers. We have the Private Employment Agencies Convention, the principal instrument that regulates recruitment, private recruitment agencies, where again, specific or special attention has to be given to migrant workers. And this is also the convention which states very clearly that workers should not be paying recruitment fees or related costs, including, of course, migrant workers. The protocol to the Forced Labor Convention also identifies, in the context of preventing forced labor, important measures that need to be, or special attention that needs to be given to recruitment processes. Okay, and particularly international recruitment processes. So it's important to note that the whole the whole range of international labor standards are relevant when it comes to protection of migrant workers, particularly the ILO fundamental conventions, also conventions of general application, which may not specifically refer to migrant workers, as well as those instruments that do give some attention, or particular attention in many cases, to migrant workers in the text. So that's important, because now we will turn our attention to looking at some of these more specific instruments, the 4 instruments that have been adopted within the ILO that are relevant to the governance of labor migration, as well as the protection of migrant workers, right? The 2 conventions, 97 and 143, which Alton mentioned at the beginning, as well as their accompanying recommendations. Okay, so let me give you a short introduction to these instruments, and particularly to the conventions. Starting with Convention 97, which was adopted in 1949. So it's a post-World War II convention, right? And World War II is very important to the context of this convention's adoption, because after the Second World War, there were large displaced populations across Europe. There was a demand for labor particularly in those countries that had been affected by the war and the need for reconstruction, and surplus labor in other parts of Europe. So one of the purposes of this, one of the objectives was to actually move people from where there was a surplus of labor to where there was a need or demand for that labor in an organized way, right? And in doing so, to also ensure that these workers moving were protected from exploitation. The scope of this instrument, however, only focuses, or the personal scope, only focuses on workers in a regular situation, right? Because they were the main category of workers moving at the time. There was little or no undocumented migration as such, right? And the instruments excluded certain categories of workers like frontier workers, seafarers, and so on. I mean, there is a reason for this. When it comes to seafarers, many of whom are migrants, of course, there is a whole body of international labor standards that is now being consolidated in the Maritime Labour Convention, which deals with this particular category of workers. Okay, and even though these other categories are excluded, it doesn't mean, of course, that they're not covered by other international labour standards. An important sort of pillar also of the 1949 convention was this reference to cooperation, international cooperation, and in the accompanying recommendation to the convention, recommendation 86, there is a model, a bilateral labor migration agreement, which has been drawn upon by a number of countries in developing their bilateral agreements on labor migration. So there's a definition of migrant worker in the instrument, which I've included on this slide. So it includes anyone that is that moves from one country to another and is employed otherwise than on its own account. So this excludes self-employed, right? And as I mentioned earlier, it's only the convention only covers those who are regularly admitted, right, as migrants for employment. So convention essentially, and I've already alluded to this, it regulates the conditions in which labor migration takes place. So it has provisions on provision of free and accurate information, the measures that need to be taken to facilitate departure from the country of origin, and measures along the sort of migration journey and so on, as well as general protection provisions, including for those who are admitted permanently into the country, right? And provisions on equality of treatment. And here, I just want to draw particular attention to this, because even though this convention dates back from 1949, it has a very strong equal treatment or equality of treatment clause in Article 6. So it's equal treatment without discrimination based on nationality. This is equality of treatment with nationals in the country, right? As well as race, sex, and religion. With regard to wages, working conditions, membership of trade unions, collective bargaining, accommodations, social security with some limitations, employment taxes, and access to justice. So, these are the kind of core areas where equality of treatment needs to be provided. And of course, when we talk about wages, subsequent ILO research has shown, as with, we know that there's a gender wage gap, there's also a migrant pay or wage gap, right? And so there continues to be discrimination between migrant workers and nationals when it comes to to payment of salaries, the level of salaries, and so on. And we also find in some countries that there is also discrimination between different groups or different national groups of migrant workers when it comes to wages. And this is the case also in the Arab region and some countries in the Gulf in particular. So that's Convention 97 in a sort of a snapshot. Now, why was there a need for, if you like, an updated convention in 1975? Well, again, in contrast to Convention 97, where there was this post-war historical context, right? The historical context for Convention 143 was rather different. Here, there was increasing concern about abusive, irregular migration, right? So that because this convention was adopted at a time, again, in the European context, but also because at the beginning of the 1970s, there was this oil crisis in the Middle East, which led to generally an economic downturn globally. And for example, in Western Europe, there was a stop on immigration to Western Europe, right? And of course, whenever you have restrictions on migration, the likelihood is that there will be people will want to move anyway, and they're more likely to move in an irregular manner. And this is what was occurring at this time. So and then people were entering the labor market, migrants were entering the labor market, working informally, and being, as I mentioned at the beginning, why do we need to give more specific attention to migrant workers? Well, we find that if they are working irregularly, they're more likely to be subject to abuses, right? So this was a context, and so the convention aimed to sort of address this, but in doing so, it also sought to provide minimum protections for all migrant workers, including those in irregular status. Because if you recall, Convention 97 only applied to those who are in regular status, right? And Convention 143 is a flexible instrument. It has two parts, and those states who ratified can exclude one part or the other. In reality, all of those that have ratified, with the exception, I think, of one country, have accepted both parts of the convention. So again, there's a definition, but in contrast to Convention 97, all migrant workers are protected in Part 1, not because Part 2 continues to apply to those migrant workers in regular status. And the list of exceptions has been sort of expanded a little. It includes persons coming for training and as well as students. They're excluded from Convention 143. But that does not mean, of course, that students who work do not get protection under, the other range of labor standards, and in particular the fundamental conventions I mentioned earlier. And also workers that come on sort of specific temporary assignments are excluded. It's a very sort of specific definition there in part, but only from Part 2 and not Part 1. So looking at Part 1 of Convention 143, it has a very important provision in Article 1, which states that the basic human rights of all migrant workers have to be respected. So this clearly covers those in an irregular status. And when we talk about basic human rights, we're talking about the fundamental human rights in international human rights instruments. We're talking about the fundamental ILO conventions as well, right, that I mentioned earlier. So this is what we mean by basic human rights in this particular provision. Another important element is that the part 1 of the convention says clearly that if you are in regular status but you lose your job, you should continue to be protected. You should not fall into regular status as a result of losing your job, and you should be given some time to find alternative employment. But this is not the same, of course, as saying that you would have a right to permanently stay in the country, right? And there are also specific rights afforded to migrant workers in an irregular situation, particularly those rights that arise out of past employment. So part 1 of the convention does not preclude governments from detecting those in irregular employment and requesting that they leave the country because they don't have regular immigration status. But if they have worked, they should be able to recover what is they're entitled to in terms of wages and other entitlements, right? They should also have equal access to legal proceedings, not have to pay for the costs of their own expulsion. And there are also provisions in part 1. It's not an obligation, it's not a firm obligation, but encouraging, let's say, states to consider regularizing those in an irregular situation. But there are also provisions in part 1 obliging countries to detect and prevent irregular migration and to prosecute those who traffic migrant workers, who facilitate irregular migration. This could include, of course, employers who knowingly hire migrants in an irregular situation. When it comes to part 2, and as I said, part 2 only applies to migrant workers in irregular status, there are very strong equal treatment provisions. So building on the equality of treatment provision in Convention 97, part 2 of Convention 143 requires countries to repeal discriminatory laws and also to adopt a national equality policy in the areas outlined. This is equality between nationals and migrant workers, and to promote equality of opportunity, right? So that this is a specific requirement in part 2 of the convention. Relevant to both of these instruments, and as you're, I'm sure, fully aware, and as I alluded to earlier, the ILO is a unique UN organization because it doesn't just represent governments. Governments are not the only, if you like, entities in the governance structure of the ILO, but it is a tripartite organization representing all actors in the world of work, the employers and the workers. And not surprisingly, this is very much mainstreamed, if you like, into these instruments. So, Recommendation 86 talks about the need to consult, to have social dialogue on all general questions concerning migration of employment. And Convention 143 has some specific provisions where, in particular, social partners need to be consulted. So this is something that is important to all international labor standards because, as I mentioned, they're adopted not just by government, but also by workers and employers organizations. But their role is also built into these 2 instruments. Another feature is, and I've alluded to this earlier, international cooperation on various levels, right? I mentioned the bilateral agreement, the model bilateral agreement in Recommendation 86. There needs to be cooperation between employment services across migration corridors to address misleading propaganda on migration, and also bilateral agreements are called for, particularly where there are large movements of migrants between countries. But of course, such agreements should be grounded in international minimum standards. And we find, unfortunately, that in practice, this is not always the case. And there are gaps in this regard, where when countries of destination and origin conclude bilateral agreements with each other. So really, to sum up, when it comes to Conventions 97 and 143, and this is some of the key features, they address the governance of labor migration. They're concerned with the protection of migrant workers in the migration process. So not only at destination, but also in countries of origin and along the migration route, if you like. But they do not affect the sovereignty of countries to determine who to admit. So there's no, if a country has a policy that they do not want to admit anyone, they don't have to do so. It's within their, if you like, sovereign prerogative, right? But of course, if there are migrant workers who find themselves in irregular status, they should provide basic protections in accordance, particularly with Convention 143, which I've just covered. They are relevant for both countries because often it's sometimes misunderstood that sometimes when we talk with ILO constituents in countries of origin, they say, well, why should we ratify these conventions? They're only relevant to countries of destination. But there are many provisions in these conventions that where there are obligations of countries of origin, particularly before departure, but also on the return of migrant workers to those countries. If we look at these two instruments together, we see that all migrant workers should enjoy basic human rights, a specific feature, of course, of Convention 143. That once migrant workers are admitted to employment, they should, and they are in regular status, they should enjoy equality of treatment of nationals. There are some provisions in these instruments to address the wider social consequences of labor migration. There's not an obligation to admit family members, but in Convention 143, states should give consideration to doing so. Their raison d'etre, if you like, is that the very existence of these instruments shows that processes relating to labor migration should be regulated within this rule of law framework, which I mentioned earlier is a very important feature of a human rights-based approach or rights-based approach to migration. And as I mentioned a little earlier, they also recognize the need for international cooperation at various levels, right? So I did say that they have not been widely ratified, and certainly not as widely ratified as the ILO fundamental conventions. And here, I've listed the countries which have ratified both instruments: 54 ratifications for Convention 97 and 30 for 143. We'll spend a little bit of time looking at the Migrant Workers Convention, the UN Migrant Workers Convention in a moment. And you'll see there that one of the features here is that many so-called Western countries, let's say in Europe in particular, have ratified these instruments, which is not the case or not necessarily the case when it comes to this UN convention, right? So the spread of countries, if you like, the geographic distribution of countries, particularly those that have ratified 97, is quite balanced, right? Although, of course, hardly comprehensive. What I would strongly recommend if you're interested in these frameworks, and particularly the migrant workers instruments, and also, because there is also an ILO supervisory system. These instruments do not exist in a vacuum. They're supported by the ILO supervisory system. So all countries that have ratified them have to report on these instruments. The Independent Committee of Experts on the Application of Conventions and Recommendations considers these reports and issues comments called observations or direct requests, which are published every year on an annual basis. And there is a report which is considered, or some of these comments are then selected for in-depth consideration at the International Labour Conference every year in what is called the Committee on the Application of Standards, right? And a general survey that the committee carried out in 2016 on these instruments. And why is a general survey important? Because it doesn't just consider, or it doesn't just ask countries which have ratified these conventions to kind of report on these instruments, but also those countries which have not ratified, right? So, and this report, which was published in 2006, considered some of the issues, why the conventions were not ratified, what were the obstacles, the legal obstacles, the practical obstacles, the misunderstandings around them, and also, garnered some information on those countries that may consider ratifying in the future. But in addition to this, and this is just one chapter of the report of the survey also gave a very comprehensive overview of what these instruments mean, how the committee has interpreted these instruments in these various comments that it's issued over the years. So it's a very rich source of information on these 4 migrant worker instruments, what they mean, and their relevance and continued relevance today. So this is something I would recommend looking at. Just a few words on the UN Migrant Workers Convention, because this, if you like, a companion instrument in the UN system, okay? And this is a very quick overview of the parts of the convention. It's a very long convention, has over 90 articles. It's a core international human rights instrument, probably the longest core international human rights instrument. Also contains a very broad definition of migrant worker. So a migrant worker is someone who is to be engaged, is engaged, or has been engaged. So it includes those who are going for work, who are working, and have worked, right, and may have returned to their country of origin, because of course they may still have outstanding entitlements, like they haven't been paid their wages, right? So it's and there are also issues when it comes to their return and reintegration in their countries of origin. This is just a very broad overview of the scope of the convention and what it covers. And it is broader in scope than the ILO instruments because it covers the whole range of human rights, civil, political rights, economic, social, and cultural rights. And here, this is where we also find labor rights, right, that are covered by ILO standards. Also, a range of migrant-specific rights. There's a prohibition on confiscation of documents. This is one of the indicators of forced labor. Migrant workers should have right to consular assistance, to transfer the earnings and savings. There's also a provision which is found in the ILO instruments, as well as free provision of information, also found in ILO instruments, right? And there's a whole part of the convention which deals with interstate cooperation. Not only to promote sound conditions of labor migration, but also to address irregular migration and to impose sanctions on those who exploit migrant workers, right? Now, just going back to the, if you like, the structure of this instrument, you'll find a little bit like Convention 143. There is a part dealing with the human rights of all migrant workers, so including those in irregular status, and some additional rights are afforded those in regular status, as well as there's a specific section on specific categories of migrant workers. And some of those migrant workers that are explicit or persons that are explicitly excluded from the ILO conventions are included in the UN Convention. So, for example, the UN Convention and vice versa. So the UN Convention excludes refugees who are working, but the ILO instruments do not, right? So there are some distinctions there. So if we look at the 1990 UN Convention as a whole, we find some of these key features. It's very comprehensive, as I've already mentioned. Again, like Conventions 97 and 143, it does not affect or impact sovereign prerogative of states to, establish criteria for admitting migrant workers to the country. It does protect the basic rights of all migrant workers, including those in irregular status, but affords some additional rights to those in regular status. There are obligations for states to cooperate. And there is also what's called a treaty body, a Committee on Migrant Workers, charged with monitoring the application of the convention by those countries that have ratified it. And again, the committee considers reports from those countries, looks at the positives as well as the negatives, issues what are called concluding observations, which are published, on the UN websites. Also issues general comments, kind of authoritative interpretations, if you like, of certain aspects of these instruments. So, for example, the committee has issued general comments. Its first general comments was actually on migrant domestic workers, which was adopted in the same year that the ILO Domestic Workers Convention was adopted. And it also has issued a general comment on the situation of migrant workers in the regular situation. When it comes to ratifications, this is the list. 60 countries have ratified. Here, however, the bulk of these countries are by and large countries of origin, right? So there's this disparity. There's a reluctance on the part of, broadly put, Western countries of destination to accept legally binding obligations when it comes to the governance of labor migration and the protection of migrant workers. However, as I mentioned earlier, a number of European countries, including countries also like New Zealand, have ratified at least one of the two ILO conventions on migrant workers, although that was some time ago, admittedly. And what's interesting about this list of countries is that even amongst those that are largely countries of origin, there are countries clearly here that are no longer only countries of origin, right? They're also countries of transit, and some of them also have become countries of destination. So again, that's interesting, I think, because it shows that the character of these countries when it comes to labor migration can change over time. As they become more prosperous, they can become that creates, like, if you like, the economy improves. There's a need for certain skills which are not available at the national level, and therefore for migrant workers to be admitted to meet labor market demands, right? So you know, a country's character when it comes to labor migration can change over time. In addition to these legally binding instruments, and certainly at the level of the ILO, there are also complementary, if you like, policy tools and guidance. And I've listed 3 key tools that the ILO has adopted, or the governing body of the ILO has approved in the last 20 years or so, starting with the ILO multilateral framework on labor migration. This is essentially a policy framework for ILO constituents on various features of labor migration governance. More specifically, the non-binding general principles and operational guidelines for fair recruitment and definition of recruitment fees and related costs, adopted in 2016 and 2019. And in 2016, also a specific policy guidance on principles on access for refugees and other forcibly displaced persons to the labor market. And as I've already alluded to, the migrant worker instruments in the ILO also cover refugees in the labor market, right? Going beyond the ILO and these broader global policy frameworks, I just want to mention 2 very key frameworks. The 2000 Agenda for Sustainable Development. This is not a legally binding framework, although it's highly relevant politically because of the commitments countries have made in this agenda. And in the agenda, of course, this is where we find the Sustainable Development Goals and targets and indicators. And here we have 2 specific targets of relevance because SDG 8 is about decent work, economic growth and decent work, right? And productive employment. And here target 8.8 focuses specifically on labor rights. And interestingly, not just labor rights for all workers, but again, specific attention is given to migrant workers and in particular, women migrants, right? So, and of course, when we talk about labor rights of these groups, we then need to refer back to international labor standards, the fundamental rights, as well as the specific technical conventions, including those protecting migrant workers. That these are important reference point for the realization of this SDG target. And of course, then we have target 10.7, which focuses specifically on facilitating orderly, safe, regular, and responsible migration, including through the implementation of planned and well-managed migration policies. And that, of course, also, by definition, includes policies in all aspects of migration, including specifically on labor migration. And finally, the Global Compact for Safe, Orderly, and Regular Migration, which I'm sure many of you have heard of. Again, it's a non-legally binding framework, which was adopted by the United Nations General Assembly in December of 2018. So it's non-binding, but you know it includes important political commitments. It has 10 cross-cutting and interdependent guiding principles, which include human rights, also gender responsiveness, and the need for whole of government to whole of society approaches. There are 23 thematic objectives that contain a range of actionable commitments. The Compact endorses the UN network on migration, which ILO is a part of, which supports the Global Compact's implementation. At the regional level, there have been a number of reviews of the Compact back in 2021 and most recently last year and this year. And there is a sort of coming together, if you like, at the global level to review implementation of the Compact in what's called the International Migration Review Forum. The first was held in May 2022. The next will take place next year, probably also in May. Now, of relevance here is that decent work and labor migration is covered in the compact, and particularly in those objectives that I've listed there. And they obviously relate to many of the issues that I've already spoken to when it comes to the migrant workers instruments and other instruments of relevance to the protection of migrant workers, right? So you've got, Objective 5, regular pathways for flexible pathways for regular migration, including labor migration, fair and ethical recruitment and decent work, skills development, etc., as well as social security, social protection, right? Which are all covered by broader international labor standards and the specific migrant worker instruments. So, and in fact, the compact also rests on international law. It says this explicitly. It's non-binding, but it rests on international law, and it does reference both the ILO migrant worker conventions as well as the UN Convention on Migrant Workers. So this should be seen as complementary to the international legal framework and not something that's separate or even something that replaces by that framework. That is certainly not the case. So that's it in terms of this overview of, in the international legal framework with a particular focus on labor standards when it comes to the protection of migrant workers. And I hope, Elton, we still have some time for questions, comments, etc. I'll stop sharing my screen.
Thank you very much, Ryszard. Definitely, we have a couple of questions in the chat that I can read out loud to you. I mean, the first one that I got minutes ago was from Merville. It's in French, but I got a translation here, so I hope it's I got it right. So she was asking if cross-border workers, let's say travailleurs communautaires, if they also have the status of migrant workers. I don't know if she's referring to, for instance, workers that are from the same regional community, like let's say the European Union, ECOWAS, or this kind of regional integration, you know? So that might be the first one. You want to get a couple of questions together so you can react to them?
I can react to the first one. I mean, it's a good question, actually, because we know that, and particularly in the context of the European Union, right, that European Union citizens or nationals which move from one member state to another are sometimes not considered. They're referred to as EU citizens or European citizens, and they're not considered by migrant workers as such. However, the answer is yes, that they, according to international law and including labor standards, they fall within the definition of migrant workers. And I think also it's important to remember that we cannot assume, even though there are very strong equality provisions in EU law when it comes to EU nationals, working in another country. This does not mean that there is no exploitation. I mean, when the European Union was enlarged in 2004 in particular, and then we had the, large movement of nationals from new member states, particularly in Eastern Europe, there were lots of cases of exploitative treatment of those workers, particularly, again, those who are in low wage or low skilled employment, despite the existence of these very strong provisions. And interestingly, I mentioned Article 6 of Convention 97, right? Article 6 was, if you like, almost like a model for the equality provisions in European Union law. They drew on Article 6 of Convention 97, which, if you recall, was adopted by the ILO in 1949, right? So there's this connection between those standards and what was eventually agreed to at the European Union level. And yes, I mean, of course, then we get to the kind of trickier issue, if you like, of the apparent distinctions that are made in the European Union between what are EU nationals working in one country, coming from another EU country, that are covered by the definition of migrant worker in the ILO instruments, and those third country nationals from outside the EU, which are also covered by the ILO instruments, right? But in terms of when it comes to labor issues, there continues, or there should be, even under the EU law and the various directives and regulations that have been adopted relating to, for example, third country national workers, equality in the workplace should be realized. At least in law. In practice, that may not be the case, right? So, you know, that's a very long answer to a question, but which I think is important, right? And of course, this can also apply to other like free movement regimes or communities in other parts of the world and in other regions. Yeah.
Well, thank you so much, Ryszard. There are a couple of questions in the chat, but also, so let me get some from the floor. I see two colleagues with hands raised. So maybe I give the floor first to a colleague that is called the user. I don't know if you can maybe open your camera and your mic, and then you can direct your question to Ryszard. Otherwise, I can give the floor to Akla. Akla, I can see you. You have your hand raised. So please, go ahead. If it's in French, Ryszard, you can select English to hear.
Merci beaucoup. Je me nomme Akla Yaobi.
Thank you. I'm Akla Kaubi. I come from Togo, work in the National Agency for Employment in Togo. Sorry, but we hear him very badly. First of all, thank you for your excellent presentation. That was extremely technical for me. And I really appreciate it because it's important for us to know all these details. I have a question. If we consider in general migrant workers, men and women, there are specific categories which are at risk of exploitation. So there are vulnerabilities that have to be taken into account. So in case of irregularities or inequalities, maybe migrant workers sometimes do not have the choice. They are obliged to leave the country and go somewhere, and they need a salary. So how can they react in case of inequalities? Because the reality is this: the ILO and we spoke about international instruments, conventions, which are binding. So what can we do, or what can the ILO do in order to force governments to really implement specific actions in case of irregularities and inequalities? Thank you very much.
Maybe Ryszard, before you reply to that question, there are two questions from a colleague in the chat that is more or less related to this one. So if I may, I will add those questions and you reply at once. Is that fine?
Yep, sure. Go ahead. Yeah.
So Shamir Brown was saying, first of all, great presentation. And he was saying like, what I want to ask is while I know that conventions are not binding, then we can clarify this, of course, because conventions are binding instruments when ratified. What can be done when countries disregard the conventions, even when they have ratified them? Yes, yeah, that was the one that links with this question. So, yeah.
Okay, thank you. I mean, with respect, okay, yeah, because I seem to remember that the first question, there was sort of another issue, right? In terms of people having no choice but to migrate for employment, and of course this is really what the development agenda is all about, right? That I mentioned at the end of my presentation. And what I think is important, we all agree, I hope, and this is a kind of mantra that's often repeated in various global discussions on migration generally, not just labor migration, is that migration should not be a necessity, it should be an informed choice, right? But in many cases, in reality, when conditions are harsh in countries of origin, or the differences in opportunities between countries of origin and destination are so great that migration becomes less of a choice or not a choice at all. And that can particularly be manifested also where migration takes place in an irregular way, right? Where it's not organized because people are so desperate to leave. Then, of course, this will, put these people at greater risk of mistreatment or unequal treatment at destination, particularly, as I mentioned earlier, if they're in a regular status. Or even if they are in regular status, because of the pressure to support their families back home, they may be less willing to even leave an abusive situation in the workplace and tolerate a lot of abuses which ordinary workers will not tolerate in the same circumstances, right? So, in the development agenda, and particularly, SDG 8, which I referred to earlier about ensuring economic growth and productive and decent work, is, of relevance also to policies in countries of origin, right? That all governments should be committed to this. But we know that in practice, at least in the medium term, many governments in countries of origin have explicit policies supporting the migration of their nationals abroad for work, right? And some are even seeking, if you like, different markets for those, or labor markets for those workers. So that's, I think, the broader context. But in the specifically on what can the ILO do when countries who have ratified or accepted the instruments are not really implementing them or failing to apply or comply with them, right? Well, I did mention, I didn't go into detail on this because I think this probably warrants, I don't know to what extent Elton you'll have electives specifically on labor standards, but this warrants more detailed discussion. I did mention the ILO supervisory system, right? And of course, this system is not just about this independent committee of experts receiving reports from governments and providing comments on those reports that are published. but there are mechanisms within the ILO to follow up on some of these comments, as well as the possibility for delegates to the International Labour Conference, so governments as well as workers and employers organizations, to bring representations or complaints. All right, and there have been recent examples where this has occurred. Around 7, 8, 9 years ago, there were complaints brought against the state of Qatar, because Qatar hasn't ratified many conventions, but it did ratify the Forced Labor Convention as well as the Labor Inspection Convention, right? And there was a complaint, particularly under the Forced Labor Convention, but also under this other convention, on various aspects relating to the treatment of migrant workers in the country, right? So arguing that there were forced labor practices and deficits in recruitment, occupational safety and health, the whole range, if you like, of labor protections. And this resulted in a settlement at the ILO, which led to the establishment of an ILO project office in 2018. And, obviously this was in the run-up also to the FIFA 222 World Cup. But that work continues in Qatar through, an ILO presence on the ground. Again, this is relevant to the region I'm in, of course. Another more recent examples of complaints that have been brought last year and this year by two of the global unions, particularly the Building Woodworkers International, as well as which largely covers the construction sector, as well as the International Trade Union Confederation, against Saudi Arabia on similar issues to those concerning Qatar, right? And this is something that is ongoing. And the ILO also hopes to establish, or has a program with Saudi Arabia that has been ongoing for a number of years, and it is expanding that program to address some of these issues that have been brought up in these complaints when it comes to the treatment of migrant workers in that country, right? So they're just two very recent examples from the region where I'm currently based, which show, there are means of action to engage with these countries and follow up and to ensure their compliance with these conventions that they have ratified. And there are other examples as well, also from the Committee of Experts comments, which have been applied, where governments have made changes, not necessarily straight away, but in time, with regard to comply with these instruments. So it's important to see these instruments not just as something that's there on paper, but also something that can be enforced in time, or at least where countries can be encouraged in time to comply with them through certain supervisory mechanisms.
Thank you so much, Ryszard. We've got two additional questions that are quite interesting. Maybe we can get them. So the first one is from Sophie. So her question is to know how labor inspections and enforcement mechanisms can be strengthened to protect the rights of all migrant workers, including those in irregular situation, and also what strategies could be employed to ensure migrant workers have access to justice and remedies when their rights are violated.
Okay, thank you for those questions. I mean, I'm not, an expert on labor inspection, occupational safety and health, but clearly, an important convention is the Labor Inspection Convention. It's an ILO governance convention, right? So when we're talking about those employment sectors, which have large numbers of migrant workers, clearly it's important that, labor inspection services give specific attention to the situation of migrant workers, which unfortunately is not always the case. And, in the region I'm in, sometimes there have been incidences where labor inspection has been tasked in detecting migrant workers' immigration status and those in irregular status, with a view to facilitating their departure or deportation from the country, rather than focusing on ensuring good working conditions in line with, national laws and international standards for all workers, including migrant workers, right? Which is, an important function of labor inspection under the Convention 81, which is the Convention on Labor Inspection. So clearly, this is one area how labor inspection can be strengthened, where labor inspectors do their job as ensuring decent working conditions and not act or do the job of immigration officials. That's one example. Clearly, another way is to strengthen labor inspection in those sectors where there are challenges, and particularly construction, and where there are many migrant workers, right? So particularly construction, agriculture. Often the agriculture sector is a kind of hard to reach sector for labor inspection because of, the isolation of many workers in that sector, and the domestic work sector, which is a particularly challenging work sector to inspect because there's this tension between ensuring decent working and living conditions for domestic workers and the privacy of the household. There are many examples of how this can be addressed in various parts of the world. I won't go into details now, but there are examples of how this can be done. So that's just some examples. And on access to justice, apart from obviously those provisions in the conventions that I mentioned, talking about equal treatment for migrant workers when it comes to access to justice. Clearly, there are a lot of, and again, I can give examples from this region. In this region, there's a lot of innovation when it comes to access to justice. Digital complaints mechanisms have been adopted across the region, also in the wake of the COVID-19 pandemic, right? I mean, this is where really there was a greater focus on digitalization in this context. However, there are still gaps that when it comes to language, right? Length of proceedings, ability of migrant workers to remain in the country until the proceedings have run their course. And even when they have run the course, the enforcement of judgments in their favor, right? Issues around, the whole issue of sort of cross-border justice, what happens when migrant workers return to their countries of origin? How can they still participate in legal proceedings, whether it's virtually or through representatives of destination? Whole range of issues that can be improved if more attention, like I mentioned at the beginning of my presentation, more specific attention is given to the specific situation of migrant workers in the context of labor complaints, right? And of course, when we talk about access to justice, we're not talking just about proceedings before the courts, but also various dispute resolution mechanisms, whether they are at the level of the company or in those ministries, particularly the Ministry of Labor, which has a remit in this area, right? It's a big topic. And it's something that we are working on in this region. We have a number of development cooperation programs where, access to justice for migrant workers are a key component.
Thank you, Ryszard. Thank you very much. Maybe one last question before we close. Eric Corso, he's asking, could you please speak about the relevance of Convention 143 today? From the brief description you gave, it seems that it was directly formulated to respond to situations of irregular migration. How are countries who have ratified Convention 143 using the convention dealing with these types of migration issues today? Additionally, from a quick check on Armlex, it seems that 30 countries have ratified the convention, mainly European and African countries, and 1 country in Latin America. Therefore, is it widely referenced outside of those regions?
It's a long question,
Yeah.
and a good one, and obviously someone who I think I know and is very familiar with the ILO and its processes. It's a good question, right? I mean, the whole issue of, one of the reasons, and we're talking about a 1990 convention on migrant workers. I know this is also relevant to Convention 143, which you've mentioned, but one of the reasons, explicit reasons, that have been given by certain governments why they've not ratified the Migrant Workers Convention, because they claim it gives too many rights to those in irregular status, right? And actually, it's not true, because basic human rights obviously are applicable to all persons, right, regardless of immigration status. But both Convention 143 and the UN 1990 Convention make this distinction, right, and allow for, heightened, if you like, protections in certain areas, not in those fundamental human rights areas, but in certain other areas for those, regular migrant workers, right? And it's true that this is, very much a bone of contention, even in, discussions on migration, whether it's, at global level, but particularly at the national level. And we see this play out in a number of countries today, particularly those, let's say, that have more conservative governments. And that's sort of, a very kind of broad description of the political spectrum, right? But of that part of the political spectrum. But there have been some examples. One example from the ILO supervisory system that I can refer to, and this dates back a few years now, but also kind of relates a little bit to what politically is happening today, was Italy, for example, is one country that has ratified both ILO conventions on migrant workers, so Convention 97 and 143, right? And some years ago, under the, if you remember, the Silvio Berlusconi government, Italy introduced very kind of draconian measures to address irregular migration, taking away many of the rights, or at least restricting many of those rights that migrant workers in a regular situation should have under the ILO standards. And the committee did, push back on this. And it's, common knowledge that the policies did not go as far as they could have done, because Italy was a signatory to these 2 ILO conventions, right? So if you like, the conventions acted as a kind of a bulwark against more draconian measures in this regard, because the debate that ensued in the country in the context of these proposed restrictions and the fact that the Italy was a signatory to these two instruments, right? So that is one example I can sort of think of off the top of my head. And the committee of experts, if you look at the various comments, there are lots of comments around part 1 of Convention 143, and the questions often asked, do irregular migrant workers have rights arising out of past employment? We know that in some countries, and I won't mention the country, where if you're an irregular migrant worker and you're not paid your wages, you have no right under the national law to recover these wages because of your immigration status. This is contrary to part 1 of Convention 143. So the committee, does ask questions to countries, what are they doing in this regard, particularly, to those countries that have ratified. Admittedly, relatively few countries that have ratified Convention 143.
Well, thank you so much, Ryszard. I think with this, we reached the end of the session. So thank you so much. And thank you all for the participation, for the questions. It was really interesting to have this debate. And it's always very good to have this level of engagement. So we hope that we keep the engagement high in all the sessions, not only online, but also when you come to Turin. One maybe final announcement, as from next week, you will be able to see on the eCampus the elective online sessions that you can take on your own. Those elective online sessions are self-guided tools that will be either on skills dimensions, social protection, BLMAs, bilateral labor migration agreements. So you can select your preferred one on the elective online sessions to complete as part of the whole structure of the academy. That is going to count some points for the final assessment. In addition to that, if you still have experiencing any problems in accessing eCampus, please let us know. Send us an email so we can make sure that we can give you the right assistance, and also be reassured that apologies, that the presentation and the recording in English and French will be available on the eCampus. If not today, by tomorrow, you can have access and revisit the presentation. Okay. So, Ryszard, thank you once again. Thank you very much. We speak soon. And colleagues, participants, thank you very much for staying connected until the end of the session. And thank you, Barbara and Claudia, the interpreters, for doing the interpretation today for the participants. So thank you very much all. I wish you all a very good maybe morning, afternoon or evening. And I see you next week on Tuesday morning, 8 a.m. Turin time, and then Thursday, 2 p.m. Turin time.
Thank you, everyone. Thank you, Elton. Bye-bye.
Thank you.
Thank you.